Hello everyone, welcome to Simply Legal. My name is Terry Kahuma, the usual host on this channel, and today I'm here to talk to you about different legal tips that will help your day-to-day life. Today I'm here to talk to you about grant of custody. In many situations in Uganda, we have different kinds of issues in our day-to-day lives. We have issues of adoption, divorce issues, paternity issues, and the likes. You know what you're going through. However, the law can always be here to help us. What is custody of a child? Custody of a child is an order given by court that considers all the circumstances concerning a child, and these are all granted to a parent of this child. In most cases, this is singular, meaning one parent. So, in many cases, grant of custody is given to different couples. We have different kinds of couples in Uganda. We have married couples who are intending to divorce. Then we also have couples who are cohabiting, or parents who just were able to get a child without even either living together or doing these other things. But what is considered in terms of custody? The court considers a number of issues, but in the best case scenario, they look at issues concerning the welfare principle. What is the welfare principle in terms of law? Welfare principle is looked at in accordance to Section 3, Subsection 3 of Children's Amendment Act of Uganda. What is considered under the welfare principle? What does welfare mean? Welfare basically means the well-being of this child. The well-being of this child concerning the emotional and physical needs of this child. So this basically means how well is the child going to be taken care of if we grant you custody, you who is claiming to be the person who wants custody of your child. So what is considered under the welfare principle? We look at the age of the child, we look at the emotional needs of the child, we look at the best wishes of the child, or look at the financial needs of the child. Let me just explain all of them. In terms of age, the court is going to consider how young are these children, how young exactly can we, who exactly can we give these children to? Is it the mother? Is it the father? If they're below 7 years, then in most cases they belong with the mother. In fact, if they belong with the mother, they should be below 7 to 5 years, about there. Then let's look at the financial needs. In most cases, the grant of custody is given to the child, to the parent who can be able to afford these children. Then we also have the best wishes of the child. Who does the child want to be with? Do they want to be with mommy or do they want to be with daddy? And then also the emotional needs. How young are these children? Which parent do they need at a particular period of time? So now that I'm done with that, let us now go to the best steps that can be able to help you get grant of custody of your child. Court that is in charge of a grant of custody is the Family and Children's Division of the High Court or Magistrates Court. So this basically means that a judge is going to preside over this petition. Step number 1, you move any family issue in the family court by way of a petition supported by an affidavit. Then in most cases, this petition is going to be served onto the respondent being the other parent of the child, and they can be able to give a reply. Afterwards, after the entire court process is done, then the judge is going to give a grant of custody to the parent who deserves to be given custody. In most cases, you can be also put issues of maintenance and all the other issues. So thanks so much for listening to me, everyone. I remain yours truly, Terry Kahuma. If you want to get more content, please go to my YouTube channel, which is Simply Legal by Terry Kahuma on YouTube. I'll see you next time. Bye.